Sources of the law. Now, this is your foundational chapter. And what I mean by the foundation is like building a house. You want to make sure that you do have a strong foundation in order for your building to stand, right? So think of the whole course as a puzzle, putting the puzzle together. And there's a lot of pieces involved, and you're probably going to feel super overwhelmed from the very beginning, saying, oh my gosh, where do I start? We're going to help you to put those puzzle pieces together, right, in the right places at the right time. And yes, you will feel overwhelmed in the beginning because it has a lot of information. There's a lot of, as I said, pieces everywhere. But by the time we finish the puzzle, by the time you finish the course, you're going to feel on top of the world. You will know the information, you will know things. At this point, as I said, if you need to cry, go cry in the shower, go punch a door if you need to. No diets at this point, right? We're gonna dive deep in this course, and it's not gonna be as bad as you think. Okay, so just give yourself some time and definitely rewatch the videos, watch different instructors, right? And then follow the flow that we created for you. So sources of the law. The first thing we're going to talk about, where did the law originate from? Real estate law. Where did it all start? It started with this guy. That was the king, William the Conqueror. He is the one who already understood that land is an asset, right? It's something that is very valuable, right? And in order for him to keep his people going, right, and be happy, he said, look, I'm not going to give you the actual land because I want to own the land. I want the crown to own the land. So I'm not letting you own the land, but I will let you use my land, right? That's called the estate. So he gave them an interest to use the land. At that time, that was not the best interest because they could be staying there as tenants pretty much, right? So they could use the land as tenants. And he says, I'll give you that land, but in return for your services. As long as you serve me and as long as I'm happy, then you can use my land. But if I'm not happy with you or cut your head off, right? Guess what happens to the land? Then I take the land back. So that's where it all started, and that's called the real property law. Right? He would pass it on to his knights and barons, and those guys could pass it to millroads, their peasantry, right? And as soon as these guys lose their rights and they don't produce value for the king, then the king takes back all the land. Right? So kind of the foundational thing. Up to this date, we still deal with estates. You'll hear me talking about estates in different chapters. It's your rights towards the land. And guess what? If I ask you a question, let's say you paid millions of dollars for your property, do you actually own the property this date? Like this day and age, do you actually own it? No. Why not? Because nothing belongs to us, right? Not even your car. You think you have the car, but then you try to drive it without the license, right? Without the insurance. Let's see how long is that gonna take you before they take your car away? Same thing with the house. If you don't pay your taxes, it's never yours. It all belongs to the crown. Right now it's government, right? They have the underlying title towards all of the lands in Canada. So yes, when we pay a lot of money and we're thinking that we're buying the property and we're thinking maybe it's ours, but at the end of the day, nothing is ours, right? It all belongs to the crown. And if they find a better use for your land, can they come and take it away from you? Oh yes, they can. That's called the expropriation right. So the government has the rights to take the land back. So an example they talk about is your ownership absolute. There's no such thing as an absolute, right? You haven't paid the taxes, thank you. The land goes back to the government. If the government finds a better use and they want to build the airport instead of your house, do you think they'll ask for your permission? No, they don't have to ask for your permission. They'll just take the land away. They'll expropriate the land and pay you a fair market value, whatever they think is fair, right? So that's kind of how it works with the government, right? So they can expropriate. Now, when it comes to our title, our estate, right? Our interest in the land, the way that we register the titles, different provinces have different systems. So on the west side, British Columbia, Alberta, Saskatchewan, Manitoba, we all have the torrent system, and that's how we protect our title through the torrent system, which I'll teach you in a different chapter. Right? But if you go towards the east side of Canada, Ontario, they have a completely different way of creating the systems in there, right? Protecting owners. So yes, legislation, the government dealing with the real property can vary widely through all the provinces, right? So just know that whatever I teach you in this course is specific for your province only. Let's talk about the sources of the law. Now in this chapter, we're going to compare the common law, the equitable law, and the statute law, and then we'll have to figure out which one will win, which one will prevail in court system, right? And there's a lot of keywords that you have to pay attention to when we talk about every single law. We're going to start with the common law. So the common law is your oldest law. Now that is the rigid. It's a very strict law. It's very inflexible law, and it came all the way from England. Right? It came from England. And this is a judge-made law. So what it means, it came from the court system where the judges come up with decisions and they wrote down those decisions. So it's written decisions that been written down. And now, if I was the judge right now, this day, I still can refer back on the common law, and I'm going to look at the doctrine of stare decisis. I'm going to look at the past cases, past precedents, and I'm going to use them as a foundation for my case. So on the exam, there's going to be a lot of keywords. So when we talk about the common law, right, I want to make sure that you know the keyword will be that it came all the way from England, right? It's a judge-made law. So it's the judges who made those laws. And of course, it has to be a written decision. It can't be just a verbal decision from the judge, right? We can refer to verbal stuff, right? And it's based on the doctrine of stare decisis. So doctrine of stare decisis, it's a Latin word, and it stands for let the former decision stand. Remember what I told you, common law is very rigid, very strict, and very inflexible law. So if I was the judge and you come in front of me, you said, look, Anna, somebody stole my car, I want my car back. And I said, okay, that's understandable. What I will do, I will look at the past precedents. It's another keyword that you have to know, right? Precedent is the earlier cases from the higher courts that I have to refer to. So I'm the judge, cannot come up with my own decision. I have to, it's an obligation for me to look at the previous cases from the higher courts. And if they had a case similar to yours, then I would have to take their decision and apply it in your decision, in your case. Do you see how that works? Right? That's the doctrine of stare decisis. Let the former decision stand. Right? Not my decision, former decision stand ahead of my decision. Right? And that created the uniformity. So basically, as a judge, do you think I would be able to predict what would happen in your case? Of course, right? Because I looked at the previous cases and I know exactly what's going to happen to you. For you, would you be able to predict? So it kind of created that uniformity where it becomes a bit more predictable. Right? Kind of people knew what will happen if you come in front of the judge, and if they have a common law, then you know what they probably will do in this case. Now, common law itself, as a judge, as I said, I'm not really flexible here, but the only remedy, the only thing I can help you with is I can sue, so you can sue somebody and ask them to give you money. That's it, right? Damages. For the exam, you have to know what remedy comes with each law. So if you want your car back and you say, look, Yana, but I pimped it out, I put nice wheels, and I made it look so cool. I said, I know, but I have to look at the previous case. And I only found the shitty car in here, so I have to apply that case in your case. And the only thing that you can ask for from me as a judge is to sue the other person for money. So I cannot ask for the car back, but I can ask those people to pay you something for that car, right? So you see how it works? Very inflexible, not the best thing. So based on the common law, can you get your car back? Not really, right? And the only thing you can do, you can only sue them for those damages. So as a judge, my question is, can I distinguish, right? Can the judge distinguish the former case? So can I say, I don't like the old cases, I looked at them, right? Now what is distinguish? It's just kind of for you to know it's set apart of being separate or different, right? That's kind of what that is. And I said, look, I don't want to, right? I don't want to look at the previous decisions because I think your case is different. And I think your car, yes, you pimped it out. It's so much better than all the other cars I found, right? So can I make my own decision then, right? And they say, yes, you can. So as long as the judge looked at the former decisions and he thinks it's different, very different, there's a lot of crucial parts in this case that was not in the previous cases, then he can come up with his own decision. So on the exam, if they ask you a question, now, by the way, your question will be on the back of your notes, right? We always have all the questions on the back. When you do questions with me, I want to make sure that you always pause me. Pause me first, go through the question, figure out on your own which one should be the answer, and then unpause me and let me explain you the question. Okay, so that's how you work through the questions. When the judge distinguishes the case on its fact, it means what? The judge decides that the facts crucial to the former decisions are not present in the case on hand and does not follow the former decision. Okay, he does not want to follow the former decision. Or the judge follows the former decision because the same facts exist in the case which has been decided. So we know that it has to be option number one because that's what distinguishes. He wants to make his own decision. Okay? Now what if I looked at every single case in the whole province and then I went through the whole Canada and I can't find not even one case just like yours. Apparently nobody ever stole the car. Nobody stole the car in Canada, you know, everybody's nice. So what do I do then? Do I make my own decision then? Or do I have to go all the way to a different country, whoever has adopted the common law? Can I go to England? Can I go to, I don't know, Australia if they have common law? What do you think? Yes, I can. And that's kind of how it works with the common law. Right? They want you not to make your own decisions. They want you to refer to the previous judge-made decisions and then apply it to your case. How about this? True, false? Judges utilize the doctrine of stare decisis to prevent the uniformity in the law. What is the doctrine of stare decisis again? Let the former decision stand in front of your decision, right? Let the former decision stand. It says, doctrine of stare decisis to prevent uniformity in law, that is false. The whole idea of the doctrine of stare decisis is to create the uniformity, right? And that's kind of what they're trying to do here, right? They say, look, we want all of the decisions to be predictable, right? With some certainty, not all certainty, but with some certainty. So for that reason, it becomes a false statement because it says to prevent the uniformity. So highlight that keyword. Which of the following option with respect to common law system is true? So when you do questions like this, you always have to check and see what do they want. So here you talk with common law. Think of your keywords and see what they want. Do they want true or false? That's the first thing you do. Then you scan the options. When I say scan it, that means you're looking for those keywords. Option 1, common law is a statute-based federal parliament-made law. Parliament. Statute-based. Who made the laws on common laws? Who actually is in charge of those laws? It's not the statute, it's not the government, it's the judges. It's a judge-made law. It's the judges who came up with these laws, right? So for that reason, that becomes a false statement. Common law system originated from France? Nope. You know, the keyword should be from. Good job, from England. Previous decisions from courts in Saskatchewan are rarely followed due to rapidly changing social conditions. No, the whole idea of previous decisions, so we can refer to them, rarely followed, that's not good enough. So, but again, if you're not sure about this option, skip it, go for the next one. Essential concept of the common law system is the stare decisis, right? And that's your keyword because you know that common law comes with that stare decisis thing, right? So you kind of have to know your keywords. Okay, so we talked about the common law, rigid, strict law. Now we have the equitable law. People said, look, this is not fair. You can't, I want my car back. I don't want the money, right? It's not what I want. It's not fair. The common law is just too rigid. It's too strict. So at that time there was a king and the king says, okay, no problem, people. I'll create a separate court system for you, right? Court of chanancy or the court of equity. And this is where you can come and deal with your matters there, right? It's the whole idea of the equitable law, or the law of equity, is to create the fairness, right? It's to relieve from the harshness of the common law, to create a fairness in the system now. But now, so again, if you want your car and you don't want the money, you probably want to go towards the equity courts, right? And what's nice about this court is that the judge has 3 different remedies in here. So under the common law, there's only one remedy, which is what? Damages, which means money. Good. And if I was the judge of the equitable law, or courts of equity, then I would have 3 other remedies, right? 3 remedies here. Injunction. When they say an injunction is when you can stop somebody from doing something, right? So I can stop and say, hey, you punched the other person, you stay away from him 300 meters. An injunction. I'm putting an injunction on someone, stopping them from doing something, okay? Specific performance. Now, this is where it's the most common remedy in real estate, because a lot of times when people breach the contract, you can enforce that contract by going to court, and they specifically tell you to follow through with your contract. Right? So that's kind of what that is, right? Contract can be carried out by the parties, right? That's what they want you to do, right? And mandatory injunction sounds like an injunction, but it's completely opposite. Injunction, I tell you, stop punching that person, stay away, right? Mandatory injunction is when I say do something. I make you do something against your will, probably, right? So that's kind of what it is. Make you do it and stop from doing something, okay? So, based on the equity law or equitable law, can you get your car back now? If I was the judge and I'm the judge of the law of equity, right? So can you get the car back now? Yes, you can, right? Based on a specific performance, I can specifically tell the other person to return the car back to you, right? So my question, can I, as a judge, can I mix and match the remedies? Can I say, look, I'll based on a specific performance, I can let you keep the car, but based on the common law, right, I'll give you damages. Can the judge mix and match the remedies from 2 different laws? No. And that's how you know it becomes a false statement, right? So when you look through all the things, just please watch out. They can never mix the damages with specific or any remedies under the equitable law, okay? So in 1870, okay, Judicatures Act, it actually did us a favor, and they combined those 2 laws together. So now, if I was the judge and you come to me with your car problem, I said, look, I actually can look at both of the laws. I can look at the common law, I can look at the equitable law, and I can make my own decision based on those 2 laws, okay? So, in Canada, the 2-court system are combined now up to this date. Right? Judge can apply both principles in deciding the matter, and if I'm not really sure which one I want to go towards to, the judge would always will go towards the equitable law. Why? Because it's the law of fairness. So on the exam, when they compare those 2 law systems, common law and the equitable law, just know which one will prevail. They like that name on the exam, that word. Prevail means wins. Which one will win? Which one will be stronger in court system? And you say it's the equitable law, not the common law. Okay, good job. True or false? A party to dispute who is dissatisfied with the decision from the common law court may apply separately to the court of the equity in the hope of receiving a fairer decision. Does that sound like a true statement to you? So if they, yes or no? It's definitely false, because they cannot apply separately, right? Remember the rule, how that goes, right? It's not separate. Now they are combined. So if you want a fair decision, you just come in front of the judge and let the judge to look at 2 options and see which one is better in your case, right? So it's not separate anymore. True, false, equitable remedy are always available to parties in court action as a right, regardless of the party's conduct. I'm also going to teach you to look for a very strong keywords. So in this case, they say equitable remedies are always available, regardless of the party's conduct. Now, those 2 keywords always, regardless, highlight those two, it's usually a red flag for you. It's usually an indication of the false statements. It's too strong, it's too much. What do you mean always? It's up to the judge discretion to decide if he wants to give you a remedy or not. He might even kick you out of the court. Right? In this case, it says maybe it took you too long to come to court. After 20 years, you come in front of the judge and they say, you know what, the case is dismissed. I'm not going to listen to you. It's 20 years passed by. Why didn't you come then? Right? So it could be a lot of different things, but because it says regardless and it says always, it's as I said, it's a red flag for you. It's indication that it's too strong, too much, right? And it's usually a false statement. Which of the following is an example of the mandatory injunction? So what is an injunction? Injunction, when, as I said, like stay away 300 meters, right? That's an injunction, stop them from doing something. Mandatory injunction, opposite. I'm going to make you do something. Against your will maybe, but I'm going to make you do that. Court order Sherry to stop dumping toxic waste. So stop dumping toxic waste, that's a stop, that's an injunction. It's not a mandatory injunction, so it's opposite, right? So that's not this one. Court orders, what is it? Isaiah's to pay $5,000 to cover Alistair's medical expenses, right? $5,000 pay, that's damages under common law, so that's definitely not mandatory injunction. The court orders Sue to remove a fence encroaching on his neighbor's property. What happens here, right? So he makes him do something. That should be mandatory injunction, but make sure you read all of the options before you pick one. The court orders Solfi to stop trespassing, to stop, right? That's an injunction. So definitely has to be option number 3 because he makes him do something, right? Makes him do something. Okay, which of the following is true? Always check the question, see what they're asking for in respect to the relationship between the common law and the equity. So now this is where they compare those two laws, right? Your job is to figure out what they want. True statements. Judge can apply common law principle or equitable principle when deciding the matter, but never both. One sec. These days, remember in 1870, they combined those two systems for the judge to look at both laws. Yes, he can pick one at the end, the remedies, right? But he can decide which one is the better fit. But when they say never both, that becomes a false statement. The common law system emerged in response to perceived unfairness in the court of equity. It should be opposite, right? It's the equitable law came in emerged to response of the rigidity or unfairness of the common law. So they reverse those two things. That's false. Common law is discretionary in nature, where the equity operates as a rigid rule-based manner. So no, it's the common law that is rigid, not the equitable law. So if there is a conflict between the principle of equity and the rules of common law, the equity takes priority. So that's definitely a true statement. That's what they're looking for. And I highlighted for you in red the parts that are false. So we talked about the common law. We talked about the equitable law, right? Between those two, which one is the stronger one? Good job. The equitable. And now we have the statute law. Now the statute law is the law created through the government. So the government is the one said, hey, the common law is a bit too old. It's too much. I mean, based on the common law, you can steal somebody's wife, okay? Right now, this day and age, we should not be able to steal people's wives, right? So for that reason, the whole reason of the statute law, right, the government, is to change or to alter the common law, right? Because common law is very old, like super old law, right? So it's your job, it's the statute law, it's the government job to change the common law. So the whole idea of the statute law is to change the common law, right? The legislation, which is your government, right? They come up with different acts. So every time they ask you legislation is, you're looking for the word act in there. So if it's an act, that is a legislation created by the governments, right? It could be a land title act. It's a very common that we're going to be using in this course, or the real estate act, right? That we're going to be using in this course. But if I say the act, that is the statute law created through the governments to change the common law, right? To do some changes. We have 3 types of governments. The federal government, that's the big guy, right? He's responsible for big matters, right? Banking is one of them. Bankruptcy is a huge one. The currency, right? The postal office is a federal. The marriage and divorce too, right? So apparently it's on the federal level if you're getting divorced. Criminal matters, right? Patents, copyright, shipping, fisheries, national defense, which makes sense. But on the exam, they'll talk about education. And they'll say, look, is that federal government who decides what type of education you will get? Do you see? We teach in so many different provinces, right? So, and every province that I teach you guys, we all have different licensing steps to get licensed. So if in British Columbia, there's only one exam, right, to get licensed for the real estate, right? If you go to Saskatchewan, there's going to be 2 exams, right? If you go to Manitoba, it's going to be 4 exams. So every province has totally different systems. Why? Because it's a provincial government that's responsible for the education, for the administration of justice. That's another thing they're asking for. So provincial, they're responsible for the justice system, right? Police and everything else. Property and civil rights, municipal instructions, right? So this is what they're responsible for. But the education, as I said, it's not federal, right? It's a provincial government who is responsible for that. Now, provincial government is overwhelmed. They have so many responsibilities, right? They're dealing with municipal institutions, and there's just so much. Okay, so what they've done, they created for themselves the local municipal governments. And those local municipal governments, they are responsible for all the jobs the provincial government gives them to do, right? So the provincial delegates the responsibility to the provincial, but the provincial itself have no authority to the legislation system. They cannot come up with new rules or anything like this. They cannot change the common law, right? They're pretty much only working with the bylaws, right? That's, don't build higher than whatever, right? That's the local government, basically. Okay, so just know the differences between the 3 types of governments too. So you remember how I said the common law is a foundational law? So you see under the common law, for example, the rules when it comes to licensing, it says an infant can write a contract, right? You don't need to be licensed. And now the statute law overrode that and said, no, right? We want to make sure that whoever is selling the real estate, they have to be licensed under the Real Estate Act, right? You see what I mean? So anytime you see the word the act, that's the statute law, right? It's the change that they created to change the common law. So if I ask you a question, if I was the judge and I had to look at all 3 laws, right? Common law, equitable, statute, which one do I look at first? Okay, it already says in there, right? You look first at, of course, at the most recent laws, which is statute law. And if I don't see the answer here, then I can go back and look at common law and the equitable law. Hopefully by now you already know which one is the stronger one, right? As you see, common law is a foundation, then we have the equitable, then we have a statute, right? So statute will prevail over all of them, right? It's the strongest one. Which of the following could be called legislation? So again, if I say the word legislation, what's the keyword that you're looking for? Anything to do with the act, right? It could be a title act, land title act, could be real estate act, anything with the act, that's a piece of the legislation created through the governments. True or false? Common law refers to the judge-made law typically recorded in the written decisions. Ooh, so many good keywords. Common law, judge-made, written decisions, where the statute law refers to the legislation enacted by the governments. So that's definitely a true statement. A lot of good keywords in here, right? Government, legislation, statute, right? That's the good 3 keywords. Common law, judge-made, recorded in the written decisions. Beautiful. Definitely a true statement. Which of the following option is not, they're looking for the false statement, a matter in which the federal government has the exclusive authority to pass legislation? Okay, which one is not? Which one is a false statement here when it comes to federal government? Criminal, definitely federal government. Bankruptcy, even the marriages and divorces is the federal, but the administration of justice within each province, that's a provincial government. Okay, so we talked about 3 types of laws. Now we're going to talk about the categories of the law. There's only 2 categories. There's a private category or there's a public one, right? So the difference between those 2, private is private. It's between the 2 individuals only. That's it, right? It's between you and Bob, right? It's between you and your wife, right? Whatever that is, it's between the 2 individuals only. For the exam, they like to use different words for private law. They sometimes will say, oh, I'll sue you under the tort law, or I will sue you under the civil law, private law. It all means the same thing. Civil matters, right? Tort matters, private matters. It talks about the law, the category between the two individuals only. So no government involved, it's only between the two people, pretty much, right? So it could be everything. You breach the contract, right? You can sue the other person, right? If it's the divorce, right? That's between the two people, right? Tort action agencies. So don't confuse that with legislation, right? That's or federal government, provincial government. This is just talks about the different categories of the law. So private between the individuals only, but when it comes to public, that's between the individual and the state, between the individual and the government. This is where the government wants to be involved. Why would they involved? They only involved in 3 categories. If you don't pay them taxes, do you think they want to be involved? Yes, they do. If you kill somebody, criminal matter, yes, they want to be involved now, right? Or if it's a constitutional matter, right? Constitutional, criminal, taxational, that's the only 3 type of matters that the government wants to be part of, right? So public law, where it's between the individual and the state. On the exam, they usually give you a simple question between those two, and they'll just ask, what are you looking at? Which one is public, which one is private? So look at this true and false statement. Tell me if that's true or false. An appeal by a taxpayer to reduce the tax assessment would fall within the sphere of the private law. True or false? It is definitely false because it's not private. It's taxes, right? Constitutional, criminal, that's a public matter. Okay, good. How about this? Which of the following falls within the categories of the public law? Divorce, property law. Okay, we're talking about public law, not federal, public. Okay, hopefully you chose the criminal law, right? Because that's what public law is about. Great. So now what we're going to do, we're going to talk about different court systems that you guys have in Saskatchewan. So basically what they're trying to tell you here that they're going to really educate you on the court system, by the way. You're going to have all your options, which is wonderful. But they want you to also understand that you don't want to take somebody to court. You want to try to settle your case outside of the court. And that's kind of where this all goes, right? So one of the first things that you should do before applying to court is go through the administrative tribunals, AT. Administrative tribunals, it's not part of the court system. So it's a separate entity. This is where you go there first, maybe. You try to settle it because it's faster than getting through the court, because now it takes, 2-3 years to get through in front of the judge. It's definitely less formal. Adjudicative bodies established to hear disputes in specific areas. So this is where, basically what they're trying to say, that this place, administrative tribunals, it's not for everyone and everything. So not all matters will be heard here. This is where they're very specific on the areas that they can help you with, right? But they will not take every single matter, right? So if you can get there, you'd better get there, right? But if you're not happy with their decision, so whatever the decision they come up with, and you say, you know what, I don't like it, can you still take that decision and rehear that, take it to one of the trial courts? Yes, you can. So decisions are reviewable by the courts. You're allowed to take the administrative tribunal's decision and you can take it to our original jurisdiction courts, which is the trial courts. So we only have 2 trial courts. One of them is called the small claims and the other one is the Court of King's Bench, right? So 2 trial courts. When I say trial courts, that means you have a judge. You have a judge face to face where you can talk to him. You can say, hey, this is my problem. He stole my car. Okay? And the judge will listen to you. They will listen to the defendant. This is called trial. So on the exam, if we're talking about the trial courts, we only have 2. The lowest one is small claims. Why do they call it small claims? Because it's limited to how much money you can sue somebody for. So if you want to sue for a car that is under $50,000, then yes, you can go through the small claims, right? So or if you even if you want more money, but you said, oh, I can settle for 50, so you can take them to this court. So 50, so money limitation in this court, that's what that is, right? It's the lowest trial court face to face with a judge. This court also has a limitation. It's not going to deal with some matters, right? They're not going to deal with anything to do with the title dispute. to your land, right? Slander, libel, bankruptcy, right? They don't want to deal with that. False imprisonment, right? Or malicious prosecution. So this is where they say, no, you skip this court and you have to go straight up to the Court of King's Bench, right? That's kind of where it goes. One or the other ones. But if it's less than 50,000 and if none of those categories apply to you, then yes, you can definitely go through the small claims. Both courts are trial courts. So if you decided to go from the small claims and say, look, I'm not happy with the judge's decision, can you appeal? Yes, you can. So Court of King's Bench, it's the highest trial court. So on the exam of the ask, which out of all of the court system that we have, which one is the highest trial? Okay. Court of King's Bench. Why? Because that's the last time you can see the judge. After this court, there's going to be no more judge, no more face-to-face with anyone, no more trial, okay? But we call it the appellate court because that's where you can appeal, right? From this court to this, you can actually appeal and go to this court. This court does not have any money limitation. It doesn't have a territorial limitation, what means you can sue them for as much money as you want and you can take them to any Court of King's Bench, like I don't know how many you guys have in Saskatchewan, but you can take them to any of those courts, right? And judge may, if he wants to, this is the only type of time out of all of the courts where the judge, if you already went through small claims, he still can rehear the whole case from the very beginning, right? He has that option in here, which is crazy. You have one judge here, you have one judge here, okay? Can you appeal from this court and go to the next court? So if you're not happy with the judge's decision from the Court of King's Bench, can you appeal? Yes, you can. And the next court you're going to go to is the Saskatchewan Court of Appeal. Court of Appeal is your highest court in Saskatchewan. So if they ask you what's the highest appellate court in Saskatchewan, you say, this is it. That's it. That's my bottom line, right? I reached it. But can you see the judge face to face in this court? No more, right? The only time you can see the judge, the trial only happens in the first two courts, right? That's the trial courts. This is just an appeal court. So what it means, now instead of just having one judge, you have 3 to 5 judges who will overview your case. So if you appeal from this court and your case went to a Court of Appeal, those judges will review the case. They will not going to rehear the evidence. They're not going to see you face to face anymore because there's no more trial here, right? And they'll come up with a decision. Now, what if they ask you in the exam to say, what is the highest appellate court in the whole Canada? Okay. Then from here we go to the next court. This is the court that does not take everybody's cases, right? This is for a major case. You kill 20 people, you're probably going to end up in there. But otherwise, you'll be cut off right here, right, at the Court of Appeal. So Supreme Court of Canada doesn't have to see every single case. They're not obligated. Look how many judges. They have up to nine judges now, right, in this court. This is the highest appellate court in Canada. So for the exam, watch. If I say the highest court in Saskatchewan, Court of Appeal. If I say what's the highest trial court in Saskatchewan, that's it. Your trial finishes up right here. You see that how it works, right? So the Supreme Court of Canada, that's the largest appellate court for the whole Canada, right? Go from the smallest one to the largest one. Which of the following statements with respect to administrative tribunals is true? So now we go back to the administrative tribunals. Remember, that's not part of the court system, right? It's a separate entity where you want to go first. Administrative tribunals are considered an appellate court. No, it's not part of the court system, right? It has nothing to do with this, right? Okay, so that's false. The decision of the administrative tribunals are not reviewable by the courts. No, they are. Remember what I told you, that if you're not happy with their decision, you still can go through the trial courts. Okay, that's false. Administrative tribunals are not part of the court system. True, they're definitely not part of the court system. Administrative tribunals hear disputes across all areas of the law. No, they're very specific, right? Limited to what they know, right? Not all the cases will go in there, for sure. So hopefully you chose option 3. Again, pause me, right? Pause me before you do any questions. I want to make sure that you think with me before I give you the answers. Which of the following statement is false? The doctrine of stare decisis provides uniformity to the outcomes of the common law system. Interesting. So, doctrine of stare decisis, remember that? Let the former decision stand. Provides uniformity. That's good. That's another key word. Outcomes to the common law system. That's true. They're looking for false statements. Always check and see what they want. Okay? So far, that's good. Supreme Court of Canada is not required to hear all of their appeals. Definitely true, right? Because they don't have to talk about your car in the Supreme Court of Canada. You're not going to make it there. Saskatchewan Court of King's Bench may exercise both common law and the equitable jurisdiction. That is also true, right? Because they are the judge now can look at both laws. An appeal from the taxpayer to reduce tax statements would fall within the sphere of the private. Now, you already know that's a false statement because taxes, it's a public matter. So you went through administrative tribunals and now you said, you know what, I still want to take the other person to court. So what do I do first? So this is what we're going to talk about, the trial process. That's where you want to take the other person to court. It says, that's it, I want my car back, right? So sometimes on the exam, they'll ask you, what is the first step in order for somebody to take the other person to court? We have to go through pleading. Pleading made out of two steps, right? It's basically its initial step and it's made out of your claim. So the statement of a claim done by a plaintiff. If you're planning to sue the other person, you become a plaintiff and you write your statement of your claim, says this is what happened, he stole my car, I want my car back, right? That's your statement. Now the defendant, if he wants to defend for himself, then he will write his statement of defense, right? Done by the defendant. It's optional, but if he decides to defend for himself, he will write that statement too. So sometimes they'll say, which one is a step of pleading? Right? It could be a statement of claim, statement of defense. Both of them are the initial steps of pleading. So after those statements are in court system, do you think you'll see the judge? Would be nice, but it takes years before you see the judge. And they don't want you to be in front of the judge in the first place, so they will push you through discovery, right? That's kind of mediation, arbitration. It's like a mini trial in here. There's no judge involved in here. This is where they will cross-examine you under the oath. So that means you have to say truth and only truth, right? Usually divorce people who went through divorce, you know what I'm talking about in here, right? The lawyer says that is, we have to go through discovery now. The other lawyer will meet up with you and they will ask you all these questions. Make sure that you know all the answers, right? No judge involved, right? Examine the opposite parties under the oath, can seize the strengths and weaknesses. So basically, if you are the plaintiff, you have the burden on your shoulders, right? We call it the burden of proof. So that means you know if you're taking the other person to court, you better have enough weight on your side of the scale, because if you don't have enough proof, if you don't have enough evidence, and if you lose the case, oh, it's going to be expensive for you because you will have to pay for the cost of the court plus all the legal fees of your side and maybe partial of the other side too. Crazy, right? So that's why a lot of cases settle right here, because they will figure out that it's probably better to settle here than go in front of the judge, right? But if you're still planning to go in front of the judge, right, then you'll go through trial. That's when you're going to see that face-to-face with judge, right? And this is where the whole trial is based on the standard of proof. So if that was me, I would put standard of proof equals balance of probabilities. So on exam, if they talk about the standard of proof, they're referring to balance of probabilities. So basically they say, look, each side will have to come up with enough evidence for themselves, right? It's like, think of the scale, right? It's balanced scale right now, but you need to put enough weight on your part of the scale, right, to win. And that's called the balance of probability. That's just a standard, right? Come up with enough evidence, enough proof to prove your case. But as I said, the plaintiff, he has a burden on his shoulders, right? And that's a heavy one because he's the one that took the other person to court, and the judge will be going after the plaintiff if his case is too weak, right? Burden of proof comes on the plaintiff. He'd better prove his case. If not, as I said, it's gonna cost him, right? And then it goes to the judgment. That's when the judge makes his own decision and he figure out who won, who lost. The person who won the case, so let's say you won the case in this case, you will become a judgment creditor. It's a credit to you. And the person who lost the case, it will be a judgment debtor. It's a debt to him. So he owes that to you. You're the creditor, right? And you're supposed to receive the money from that settlement. As I said, the court cost, right? If you lost the case, ouch, as a plaintiff, that's not good for you because you will have to pay the legal fees to your lawyer. You might be paying partially the fees towards the other lawyer, and you have to pay separately for the cost of the court. The court costs are not the same as the legal fees, right? Legal fees is your lawyer fees, right? Somebody has to pay. So basically, sometimes whoever won the case, then the other side might, the judge might say you have to pay partial reimbursement for the legal fees for your lawyer, right? And the judge discouraged people to come in with the weak cases, right? Because if you lose the case, as I said, you're going to pay a lot of costs for the hearing and costs for your legal fees, right? For everything. Think twice. Larry entered into the contract with Haley to have her renovate his rental property. Larry later sues Haley for a breach of contract. Under which standard of proof must Larry prove the breach of contract? When they talk about the standard of proof, what are the keywords that they're looking for? The balance of probabilities. So for yourself, put them as equals right now. Standard of proof equals balance of probabilities. True, false. In the trial process, the plaintiff and the defendant alternate in calling their witnesses one at a time, who are each cross-examined by the opposite side. So I haven't explained this one yet. Sorry, I forgot. But when you go through trial in front of the judge, so basically what he will do is this. He will start with the plaintiff and say, okay, plaintiff, tell me your story. And after plaintiff is finished, he's going to call all of the plaintiff witnesses, right? So he'll finish with the plaintiff side first, and only then he's going to move towards the defendant and his witnesses, and that's where all the cross-examination happens and all the things. But it's not... This is a false statement because they don't alternate in calling their witnesses one at a time. Judge will be very confused. Right? They'll do one side first, then they move on to the other witnesses from the other side. So for that reason, that's a false statement. As I said, they don't want you to go to court. They don't want you to go through the court system, so they try to push you to do something else. One of the things they try to push right now is the mediation. And this is a mandatory step. So a lot of times, the lawyers or the judge will say, you know what, before you come into court, we need you to go through mediation. That is a mandatory step, right? Court mediation program, they have specific program, CMP, administers the mediation. It is faster, it's private, it doesn't cost as much that going through the courts, and they're pushing people to go through the mediation, and they say it is mandatory to show up. If one party doesn't show up to that mediation, guess what? He's going to get in trouble if he wants to continue with court, right? The judge will just cut him into pieces. Right? Refusal to participate, court has power to impose sanction against the offending party. So make sure that you actually show up in there. But the thing is about this, that this is not... It is mandatory to show up, but the mediator cannot enforce his decision on you. This is a mutual agreement, right? So that's why they want you to do this, because they say, look, just show up in there and go talk, right? Try to settle your issues. Mediator cannot enforce the decision on you. But if you decided to go voluntary, right, towards the arbitration, this is where you have an arbitrator involved. Both parties have to show up. Both parties have to voluntarily show up in there. So it's not mandatory anymore, but the arbitrator, his decision is binding. So if he comes up with a decision, he will decide it for you, right? That's why it has to be voluntary on two sides. Two parties have to show up in there. Same thing, it's flexible, it's private, it's less cost, it doesn't cost you as much as going through the court system, right? Commercial leases, they actually include their arbitration clauses in their contracts, saying, hey, if you default on the payments, we'll have to go through the arbitration, right? So it's kind of a good option if both sides voluntarily decide to go there, okay? Hopefully you got the whole court system. So arbitration is reduced before a party can appeal a judgment, required before the party can appeal the judgment. No, it's not required, it's optional, right? Where an arbitrator assists the parties to achieve a consensual agreement. No, that's mediation. Governed by the common law, not legislation. No, common law is too old for this. They probably didn't even have the arbitration by then. Binding on both parties to the dispute. So again, arbitration is voluntary to show up, but arbitrator can bind the decision on them, right? He can make that decision. Which of the following is true in respect to mediation? So now it's mediation. Mediation is becoming increasingly difficult to access. No. The whole idea of the mediation is easy to get in, right? Court takes a long time, not mediation. Mediation is more expensive and time consuming. Definitely false, right? It's less expensive and it's way faster. In most mediation proceeding, attendance is mandatory. That has become a true statement, so that should be the one. The mediation proceeding, the mediator issues a binding decision. That's false, that's arbitration, right? So it has to be option number 3. Okay, so now they want you to know how do you enforce the judgment? So let's say the judge said, you know what? Yes, we want the other person stole your car, so we want him to pay you $50,000, right? For your car. Because you can't recover the car back. So they want you to know where do you start if that judgment debtor doesn't pay you. So creditor is the person who won the case, right? The debtor is somebody who lost it. We can't change the wording here because that's UBC and I think they made a mistake here, but the point is the debtor is somebody who lost the case, right? Creditor is somebody who won the case. So the first thing that you have to do as a creditor, so if you won the case, right, and the other person haven't paid you yet the money, you have to go and file the judgment in a judgment registry search. So you have to put that judgment in, right? You can search for the other records and see if there's any other judgments against that person, but basically your first step is to register the judgment and say, he still owes me money, he haven't paid me yet. Okay. You can also look for the title search, right? That's land title. You're looking to see if that debtor has any land, right? If he has any properties, real properties, right? And if he does, right, we'll figure out what to do with that. And then you also have such thing as called personal property registry search, right? That's the major items like boats and cars and all the other things that he might have, expensive things, right? So you can do all the things, but this step is a must, right? You must register your judgment. And if they discover something, right, then you can register that. If it's land that you discover, Land Title Acts, that's where you're going to register that judgment against, right? Or if you find the personal property stuff, then Saskatchewan Personal Property Registry, right? That's where you're going to register your judgment against, right? Enforcement injunction given through the sheriff. So that means it's not you personally who's going to be going after the debtor. The court will assign you the sheriff, right? And the sheriff is the person who will be coming and collecting, right, the debt. So if you cannot recover all your money in step number 1, so let's say they found a boat and it's only $30,000, they still owe you $20,000. Then you move on to step number 2. Step number 2 is where they start with the examination and questionnaires, right? So first it's a voluntary questionnaire that you provide to the debtor. And so look, here's the question, answer everything that you have because I'm still short by $20,000, you still owe me money, okay? And if he doesn't answer those questions, then you involve the sheriff now and the sheriff gonna ask, he'll serve him with the notice to complete the questionnaire. And if he still doesn't answer, even after sheriff gave that notice, then it'll go through the notice of the examination through the court system, where they can actually send somebody to his house and start searching for those items to find out if he has money, right? Judgment debtor must provide complete and accurate information, so don't lie. So basically, if you find that he has a piece of land, right, or if you find personal items that worth something, as soon as you put that judgment in the registry, if the debtor's name is matching to your judgment, so it's John Smith and John Smith, then it's automatically registers against the title, right? So that's how it works. It's easy. But if he has a discrepancy on his name, so on your judgment it says John Smith, but he is actually John J. Smith, then you have to do it manually, right? Plaintiff applies to register judgment manually. Okay, next one, if he has what if he owes you $20,000, no houses left, no nothing, what do you do? Now, the other thing what you can do is you can ask for the seizure order. We used to call it the garnish, oh my gosh, the garnishment order, right? That's how it used to be, right? But not anymore. Saskatchewan doesn't use that word anymore, right? So they use the seizure order. So they're referring to the wages and they're referring to bank accounts. So basically they can seize your wages. But on the exam, if they say, oh, can they come after all of your wages? It's not a communism country yet, right? So they can only come after some of the percentage, so up to 30%, right? So up to 30% that the non-garnished sees the wages, or they can come after your bank account, right? And if the third parties, which is the banks or your employers, if they don't want to provide the information, then they will be personally liable. So they have to provide with that information, right? They can't say, oh, I'm sorry, that's our client's information. They can't do that. Okay. And again, the seizure of the order pays to the sheriff. You personally don't get the money. It's the sheriff who gets the money, and then he gives it to you. Okay, this is the last part, I promise. I'm sure by now you are tired, and that's okay to pause and have a break. But I promise, the more you do these chapters, the more you listen to the same chapter over and over, and if you watch different instructors, right, that we provide, then you get all different views and different explanations. It's very helpful. So limitation period, it's under the Limitation Act, and it says that limitation acts as a default statute, right? It's just a foundation, which doesn't apply to claims under the statute laws that already have their own limitation period. So basically, it's kind of like a common law. It's a foundational, right? We have a limitation of 2 years and 15 years, but if the other legislation has its own limitations, it will override this one. Right? This is just a kind of like a common law thing, right? So the basic limitation is basically 2 years, right? That's where it starts. They say it applies to most civil claims, but it definitely applies to the physical bodily injury. So if somebody hits you with a car, you have only up to 2 years to claim it. Otherwise, the judge will say, why did it take so long, right? Somebody stole your car, try to get there within the first 2 years. That's limitation. If you come after 20 years, the judge will say, why? Why did it take you so long, right? Begins on the date of the discovery of the negligence. So that's a crucial one. So basically, let's say if somebody stole your car, and after 2 months, you discover that they stole your car because you were on vacation. So your limitation period starts from the date that you discover that you missed in that car, right? Not when it actually was stolen, on the day that you discovered that. I wish we could change the wording of that, but that's how it's in UBC books, so we have to keep it that way, right? The date of the discovery of the negligence. So when you came back from the vacation, you found out that the car is missing, that's when you start, right? Not on the date of the acknowledgement from the person who stole your car, right? It's not about his acknowledgement, it's about when you discover that there's no car. Okay, so that's the 2-year limitation period. Then we have the ultimate limitation period that is given to you up to 15 years. In your books, there's no explanation exactly what type of cases are they referring to, right? But from I've been teaching you guys for 23 years now. It's been a long time. And we had a different information before in these books, and it basically talks about, no, I don't want to say just the kids, but an infant's definitely, right? Somebody who has been injured in some way, but they didn't know what to do at that time, right? So, and they say, oh my gosh, now they realize that whatever happened to them, it's not right. And now they want to come after that person, right? So somebody who is not there yet, so the court gives them 15 years, right? To come up with that claim and says, you can still come after that person who injured you, right? So that's kind of where it's coming from. It's a very sensitive subject here, but it begins on the day on which the act actually occurred. So when you realize, maybe you realize 12 years later, right? But you know it happened on that specific date. So from that date, that's where that limitation period starts, okay? Common law, if you only want to rely on common law and sue them for the damages, right? You only need to bring the action within the limitation period, so 2 years or 15 years. But if you want to rely on the equitable law, now this is where the judge is going to look for and see, okay, limitation period, that's good, but also has to be reasonable time, right? Like if somebody hit you with the car, don't come after 20 years, don't come after 8 years. It has to be within reasonable time, right? And up to the judge to decide what reasonable is. Now, this is crazy. They say we also can reset the limitation period, and who can reset it is the actual defendant. So if I was the lawyer for the defendant, I said, please don't do anything stupid, okay? Don't apologize for hitting the other person, right? Don't give them any money or anything that they can prove that there was, that you acknowledge it in some way, that you hit them or you stole the car. Don't do that. That would be my advice as the lawyer to them, right? So here it says, the court action, the lawyer, talk to the lawyer as soon as possible. Make sure that you don't accidentally acknowledge the liability, because as soon as you acknowledge that liability, that yes, I hate you, or yes, here money, just don't take me to court. As long as they have something in writing or some proof, that's the limitation period resets to that date now, right? And now they have another 2 years from that acknowledgement date, which is crazy, right? You also have, we'll talk about REACs, which is your insurance for the real estate, but we're going to talk about this, saying that if you know about any accidents, you need to report them as soon as you know, right? That's your obligation on the real estate side. Okay, that's it. Let's do some questions and then we're done. Lisa is leasing the commercial property for 5 years term. After business hours, John trespassed on the property. Generally, what is the basic limitation period under Limitation Act? Within which Lisa may bring the legal action against John for his trespass. I mean, trespass, is that a big thing? They're probably not going to give Lisa 15 years to take that claim to court, right? So her limitation will be 2 years. We don't have such thing as 1 year. 15 would be way too long for trespassing. It's not serious enough, I think. Right? So for that reason, that's an easy question. 20, Rohan and Adeline enter into the contract for sale and purchase of Adeline's house. After the transaction is complete, Adeline decided that she no longer wants to proceed with the sale and refuses to transfer the property. 20 months later, Rohan initiates legal proceeding against Adeline for breach of the contract. Equity might not intervene because of what? So now, remember how he says, the common law says, yes, if you bring it within the limitation period, then you're okay, but the equity says it has to be within reasonable time on top of it. So if I look at the option in here, equity only operates in public law case. No. The ultimate limitation period has expired. What's ultimate? Ultimate is 15 years. It's only been 20 months, so that's not true. The basic limitation, which is 2-year period, has expired. No. 20 months, not 24 months, so that's out. A reasonable amount of time has lapsed. Yeah, so again, if I was the judge and I said, look, it's been too long, 20 months, you should have taken to court way before that, right? Because to me, reasonable would be way less in this case, right? And that's why equity will not apply, but the common law still applies, right? So you can still take Adeline to court for under the 2 years of limitation, but not sue her for equitable remedy. This is... Oh, one more question, sorry. Which of the following is true regarding the Limitation Act? Ooh, couple more. Let's see what we have. True statements. In order for the basic limitation period to apply, a claimant must file a claim under the statute that acknowledges that the Limitation Act applies. Nope. The basic limitation period only begins once liability is acknowledged. It's not about the liability. A potential defendant acknowledges a liability. The ultimate limitation period is reset to begin at the date of the acknowledgement. And that's what they want you to know. Remember what I told you? As a defendant, you please watch, right? Don't acknowledge the liability. Don't say, oh, sorry, I hate you. Because as soon as you say it from that date, let's say after 2 months after hitting somebody, then that resets. It gives extra 2 months to the plaintiff to sue you. Okay, so now it's definitely it. This is the end. You survived, so congratulations. You few pieces of the puzzle already in the right places. So my suggestion, watch it again. Watch it again, watch it again. Your job is, after you finish watching this, we have the whole structure of the course graded for you, right? We've been doing this for 23 years. You watch the video first, you follow your notes that comes with this chapter, then you come back and you do your quizzes. The questions that we give you for a specific chapter, back and forth, back and forth. There's gonna be hints for every single question where you know why is it true, why is it false, just like me explaining it to you. And after you finish the quiz, you can go for the flashcards, practice on that, and this is when you go for the next chapter. But Your job is, especially in the beginning, because you do feel overwhelmed, as I said, it's the usual thing. Your job is to breathe. Know that's okay. It's okay to feel that way. And I would just rewatch it again and again. Right? It's just kind of go slow in the beginning, and then you will see you will get faster and faster at this, because this is all new to you. Anyways, good job, and guys, we'll see you in the next chapter.